Right, good afternoon, everybody. It's 5 o'clock, so we'll make a start. My name is Andrew Schaefer from Trafalgar. I'm linking in from our Johannesburg office. I'd like to welcome you this afternoon. Thank you for your time. Thank you for joining us for what I think is a very important topic, and that is one of CSOS and how to practically utilize and effectively apply the CSOS dispute and adjudication mechanism, which will be a focus today. In a moment, I'm going to ask my colleague Peter Menon to introduce two senior CSOS stakeholders who are joining us tonight, and Peter will be engaging with them in some question and answers later in the agenda. How we're going to structure the discussion is I'm going to ask my colleague Karine Kutsia, based in Cape Town, who's Trafalgar's property management consultant, just to give us an executive summary of legislation referencing CSOS and CSOS's role in the community scheme sector. So Karine will give us a refresher and an update on that. And then following that, we'll hand over to Peter. And Peter Menon will, he's got a list of frequently asked questions, important questions and topics relating to CSOS disputes, which he will be posing both to Lindiwe and Corin as our special guests tonight. And we welcome them warmly and thank them for their time. No better way to engage in this topic than have senior CSOS stakeholders involved. Please, will you just, in the Q&A, if you would like a recording of this webinar, as well as the Q&A record, as well as the slides, please just drop your email into the Q&A. You can do it privately if you want to Karine or myself. We will extract that, and then Karine will make sure you get copies of those. We do upload recordings of all of our webinars on our training website, training.trafalgar.coza/webinars. So there will be a record of this should you want to re-listen or refer it or just know it's there. It will be uploaded there probably on Monday or Tuesday next week. At the end of the webinar, which will close promptly at 6 o'clock, there will be a short survey that pops up. If you have 30 seconds, we'd appreciate you appraising the webinar. We do try and adapt and adjust to the comments, and in particular there's an opportunity to log any particular topics you would like us to cover in upcoming webinars. Peter, could I hand over to you maybe just to introduce our CSOS colleagues, and we'll go there from Karine to continue with her topics. Thank you.
Certainly. Thank you very much, Andrew. Good evening, everyone. First off, we've got Lindiwe Bulo. Lindiwe is an admitted attorney of the High Court with more than 25 years of experience. She was a senior legal advisor for the Housing Consumer Protection Trust before joining the then Estate Agency Affairs Board as company secretary. She later became the executive manager for compliance and enforcement for the EAAB. She was also a member of the Law Committee of Arello, an association of real estate law licensing officials based in the US, used to present South African property law. Save for practicing at Bulo Attorney, she has held several senior positions before joining the CSOS as an adjudicator and currently the acting senior manager for compliance, governance, and enforcement. Thank you for joining us, Lindiwe. Corin Blaise, the sectional title scheme stalwart, requires almost no introduction. She is the co-author of the seminal volume Demystifying Sectional Title, together with Marina Constance. Corin began her career as an estate agent and sectional title portfolio manager and has been an attorney, notary, and arbitrator in private practice for the past 15 years. She is currently employed as an adjudicator at CSOS. Thank you very much for joining us, Lindiwe and Corin. We truly appreciate your time and expertise, and we're looking forward to the webinar and gaining greater insight into the CSOS dispute procedure.
Excellent. Thank you, Peter. So, Karine, we will hand over to you to continue. Thank you.
Thank you. Thanks, Andrew. Thanks, Peter. So I'm just going to look briefly at a couple of procedures where CSOS is involved and just give a brief overview. So the first procedure obviously will be step one is registration. All community schemes in South Africa, in terms of the CSOS Act, must be registered with CSOS. There is an easy way to do that. They have an online portal that is called CSOS Connect. The link is there. We use it as well, where you can quickly and easily register a sectional title scheme. It is used at the moment for registrations and annual returns, which I will talk about a bit later. But yeah, every single community scheme must be registered with CSOS. And yeah, just to say from Trafalgar's side, 95% of our schemes are registered. The reason why it's not 100 is because the 5% is new take-ons. We're still busy registering them. So they will eventually also be registered. So we make a point of registering our schemes with CSOS. If you don't, what happens? There's a fine, there's imprisonment for a period not exceeding 5 years, or both a fine and such imprisonment. Who's going to pay the fine? Who's going to sit in prison? The trustees. So yeah, very important that every single community scheme must be registered with CSOS. The next procedure that I would like to just briefly touch on is the annual returns that I was talking about. So also the Community Schemes Ombuds Service Act states that every community scheme must submit an annual return to CSOS. There's a form that you can use, or you can use the CSOS Connect system that I alluded to. It must be done within 4 months after the year end of the scheme. And normally it entails also including the AGM minutes and the audited financial statements of that scheme. So this is also a compulsory item for all community schemes. CSOS levies. So yes, you have to pay a levy to CSOS. The Act prescribes a formula on how these levies are calculated. There's some exclusions. So the monthly levy of the unit minus 500 Rand, that monthly levy means the administrative fund levy of the scheme, excluding reserve fund levy, excluding special levy, excluding exclusive use levy. So you take the administrative fund levy minus 500, the first 500 Rand is exempt from this levy, times 2% with a maximum of 40 Rand per unit per month. So that is the levy that every section must pay over to CSOS. It's raised on a monthly basis and paid over to CSOS quarterly. Another big item that CSOS looks after for us is rules. So basically the Act, the Sectional Title Schemes Management Act, says that conduct rules have to be approved by the owners by special resolution. Management rules have to be approved by the owners by unanimous resolution. And from there, it must be approved by CSOS. If your rules are not approved by CSOS, they are not enforceable. There's a process of submitting these rules to CSOS, and once they are approved by CSOS, you get a certificate stating that they are approved, and only from the date of that certificate are those rules enforceable. The last item I would like to touch on is the amendment of particulars. So this happens once in a while when, for instance, there's a management agent change. You need to notify CSOS. When the trustees change, you notify CSOS, and there's a different form to be used for that as well. So that's just basically briefly touching on some CSOS procedures. And now I hand back to Peter for the big topic, the dispute resolution procedure.
Thank you very much, Corinne. So before we get going with the question and answers with CSOS, with Lindiwe and Karen, just going to run you through the current disputes procedure available through CSOS. It's just a simplified format of sort of what you can expect as a trustee or a director or as an owner while undergoing this process of declaring a dispute at the scheme. The completion of the application form is obviously vitally important. That application form is available directly off the CSOS website. At the end of this presentation, we do have an appendix page that you can go and have a look at that has all the links. CSOS also has a fabulous set of FAQs on their site that you can go through. So I'm sure a number of these questions that is going to be asked tonight and those from the chats are actually already duplicated on their site. You just need to go and find those. Pretty simple to go and find them, but go and have a look at that appendix page after we've done the presentation. So completion of the application for dispute resolution, CSOS then receives, registers, and acknowledges the new application. This is done by way of email. The application is then assessed to determine the validity. During this process, obviously, as well, CSOS does communicate with you. They tell you in which process they're currently busy with. how far along they are with the application itself. And this is a vital part of the actual application process, is assessing whether the validity of the application is correct. We're going to be discussing later on Section 39 of the CSOS Act, which specifically predetermines what type of relief a party can ask for once they're completing this application form. It's one of the vital things that we're going to be touching on today. If the matter is valid, the matter is referred to conciliation. The conciliation fee is luckily for free. You've got two types there. You've got your informal type and your formal type. The informal type is a quick telephone consultation depending on the complexity of the matter. Your formal type is a conciliation hearing. Conciliations are then chaired by a CSOS conciliator who is there to assist the parties in finding a resolution. If the matter is not resolved, the matter can be referred by the conciliator for a notice of non-resolution through to adjudication. Once again, the adjudication fee is for free. Matters that are referred for adjudication will be subject to a thorough investigation prior to presentation at the adjudication hearing. At the adjudication hearing, the adjudicator will consider all evidence presented and will give a determination that is binding on all parties to the dispute. From Trafalgar's perspective, this process is used substantially, whether it's internal processes whereby we are actually launching applications on behalf of or for the trustees and directors. But also, obviously, this process is completely open for members and owners to utilize the disputes procedure for better resolution, quicker resolution of disputes once that has been declared. Karim, you can skip that slide for me. Lindiwe, Karen, if I can ask you to unmute and just come online for me, that would be great.
Okay.
Thank you. Because we're two today, we're going to try and do this in the best way possible. I think the easiest way of doing this is sort of like a quick fire. I'm going to go first, Karen, then Lindiwe. Whether you'd like to interrupt each other is completely up to you. I'm sure you don't disagree whatsoever. That's all the time. All the answers are 100% in line. But please feel free, if you'd like to embellish, tell us some stories about certain matters. We're not following Poppy here, so you can mention the people's names and the body corporates, I'm sure.
No, we won't.
But also what I've seen through your website, you've got this fantastic platform that actually takes a look at previous adjudication orders. So all that information is freely available, and we'll touch on those during the questions as well. So okay. Karen, if you wouldn't mind, I'm going to start with you, and then we can run through to Lindiwe. Thank you. Okay. So what are the most common pitfalls when submitting any application to CSOS?
Okay, the first thing is that if you're submitting an application on behalf of the body corporate, make sure that you are doing so with a trustee's resolution. That is the one thing, and I must say that Trafalgar is excellent when it comes to that. Or if somebody's submitting it themselves on behalf of a number of people, make sure that you have a power of attorney. That is crucial. It must be done, and you could in fact the application could be rejected on that basis if you do not have the authority to submit that application. That's the first thing. I'm trying to think what else. Make sure the application is signed. Make sure that you have evidence when you submit that application, as in any court case. I would say those are probably the two most common pitfalls. Make sure that if you have all the information, that it's properly filled in. And one of the things, and I think that you may have that in one of your questions, is make sure that you've gone through an internal adjudication process, which the CSOS demands before you actually submit that application.
Excellent, thank you. Yeah, I see a lot of these come across my desk as well, and the information is sort of sparing. It's sparse what they actually provide on those application forms. So thank you very much for that. Lindiwe, second question is for you. I see you're muted. Would you like to unmute yourself?
Okay. Thank you.
will you be assigned a specific CSOS representative to hear your case?
Yes, definitely. So the process, once the application has been assessed and everything, and it has failed at conciliation, even at conciliation, a conciliator will be assigned to your matter. Should conciliation fail, or if the matter could not be resolved at conciliation, it then moves to adjudication. An adjudicator is then assigned to look at your matter and consider it and do all that is necessary. That adjudication order will then be final. So if you're not happy with that adjudication order, you have the right to appeal. And on also, but yes, definitely, an adjudicator will be assigned to your case.
Okay, so it's a specific CSOS representative, one person that you're going to contact throughout this process.
No, it will be different depending on where the process is. If it's at assessment stage, we have case management officers. So your case will be assigned to that case management officer. The case management officer will then assign it to a conciliator if it goes to conciliation. But then if the matter goes directly to adjudication, there are instances where it goes directly to adjudication, and adjudicator will be assigned to deal with that matter.
Okay, excellent. Thank you so much. Corin, I'm going to get to you. Quite a difficult one, because how long is a piece of string? But how long does a usual CSOS matter take?
It takes 90 days from the moment it's received until the adjudication is complete. Unfortunately, at the beginning, when CSOS was first established, it took quite long. The cases took quite long, but in the last, I would say, 2 to 3 years, the process has been streamlined, and now it takes 90 days from, as I say, from the moment that a dispute is referred to us. And there are strict timelines that we adhere to, and I can assure you that the matters usually take 90 days until they are finalized.
And that's not even based on the complexity of the matter. It's going to take 90 days or shorter than that.
Yes.
Fantastic. Lindiwe, the application form is rather short. There's really not a lot of information that you can necessarily capture within that application form. Do you prefer separate documentation, so a separate Word document or a PDF document that attaches all the facts in the matter, but obviously runs through exactly the same process as what the application form details?
Yes, we do. Actually, what we prefer is just be clear and precise. You don't have to give us a long story, but make sure that whatever you've said in your application form, it's supported. You do have supporting documents. So if the nature of your application requires additional information, then definitely by all means, you can use an additional page, but make sure it's precise. When you say you're giving us a statement of case, we also have that checklist. So go through that checklist and see if this matter falls within our jurisdiction and it falls under that section 39, which part of section 39 falls within that matter. So in that case, you don't have to give us a long story, but definitely we don't have a problem if you add an additional page. Like if it's an area levy matter, there's no need to give us screeds and screeds of pages. Thank you.
I write a lot, okay.
Same here. Same here. Karen and I are adjudicators, so we write. We write a lot. So, yes.
Corin, next one for you.
But we don't.
Top tips for the manner in which disputes should be packaged and presented. What we try and do is when we try and package and present something to CSOS, we sort of treat it like a court application, like a court matter. With your attachments and your annexures preferably labeled, of course. But I mean, at the end of the day, you're sitting in front of a person who's going to hear this matter. As an adjudicator, what are your sort of top tips when it comes to in the manner in which this is packaged?
I think be as succinct as possible, be to the point, which is exactly what Lindiwe mentioned. Concentrate on your Section 69 relief. You must frame it in terms of your Section 69 relief. That is the only relief that section that the CSOS can grant. So frame it in terms of that. Be as to the point as possible. If you know of any case law, and I'm talking High Court precedent that you can refer to, use that. Concentrate on the evidence. If it is arrear levies, which Trafalgar does in any event, the most important thing is your levy statement. And I would say that that probably is the best. Be as to the point as possible. Don't forget your evidence. And just one thing, please, 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 don't ask for relief that somebody apologizes. Because have you ever heard of a court case where somebody comes and says, please, they need an apology from the trustees or they need an apology from someone? We can't grant that, and we will never grant that. So yes, those are the top tips.
Fantastic, thank you. Lindiwe, moving over to you. What to do if a CSOS ruling is ignored? So let's say, for example, the matter went through the entire process, adjudication order has been granted, but that order is ignored by the party to which the order is made against.
Okay, thank you. If an order is ignored, Section 56, 1 and 2 of the CSOS Act gives you the right to apply for an enforcement of that order. So if it falls within the jurisdiction of the magistrate's court, you apply, you request CSOS to give you that enforcement order. It's signed. You take it to court, to the registrar of the High Court, if it's for specific performance. So if it falls within the ambit of the High Court, you take it there. If it falls within the ambit of the magistrate's court, you take it to the clerk of the court. They just stamp it and then you serve it.
So that's actually made an order of court, just like with a rent housing tribunal matter.
It has the same force and effect as if it is a judgment of the court.
Okay. So sorry, I'm just going to follow up on that one. So if that occurs and you make an order of court, can you issue warrants of execution directly off that order as well?
But then that falls outside CSOS. So
okay.
Yes, you can use that, but then that's when you need an attorney to assist you. So
okay.
We go as far as issuing that enforcement order.
Excellent. Thank you. Corinne, you can swap slides for us, please. Thank you. Corinne, what if a matter falls outside of the scope of Section 39? This is one of those that crop up daily at us as well. We see these applications all across the board because there's a specific list of orders that you can ask for from CSOS. If it falls outside of that scope, what happens?
Then you can't come to the CSOS. We can't grant that relief. We are a creature of statute, and that's what is set down in Section 39 is the only relief that we can grant. However, you will see that we have a Section 39(7)(b), and that says any other order that the chief ombud may grant. Now, the chief ombud issues practice directives from time to time, and so when you see Section 39(7)(b), or when people see that, they think, okay, well, we can just put in anything and the chief ombud will look at it. They can't. Section 39(7)(b) refers to orders that are specified in the practice directive. Section 39(7)(b) specifically at this stage refers to urgent orders, so orders where, for example, electricity or other services have been disconnected without a court order. So you can't commit an act of spoliation, as you know. You can't disconnect electricity or fiddle with a prepaid meter unless you have a court order, then those can be brought as a matter of urgency to the CSOS, and we will complete those orders within 48 hours. And where life and limb is threatened, or if there are problems with hygiene, and that's also probably a threat then. So those, for example, are set out in our practice directive. We are currently working on another or an updated practice directive, and there will be more under Section 39(7)(b). So if you want to look at what falls under Section 39(7)(b), please have a look at our practice directives. They are on our website.
Fantastic. And that includes the additions to 39 as well.
Section 39(7)(b), but
Yeah.
otherwise, only within it forms what's called a numerous clauses. Those are the only things that we can grant relief on.
Okay. And like you said, there are plans obviously to expand on this list. I think probably through your learnings and through CSOS being around for a number of years.
Absolutely, and of course the Act is going to be amended, but as you know, this takes time because it has to go through Parliament.
Most certainly. Are applications currently heard in person or online, and will this change, and when will this change?
Am I answering that, or is my colleague?
I've asked Lindy. I see she's
okay,
muted.
all yours.
Sorry, I lost you there, Peter.
Oh, no problem. Okay, so currently applications, how are they heard? Are they heard online? Are they heard in person? Will this change at some point in time?
Oh, we do both actually. Now, it was because of COVID that we were not doing a face-to-face, but the online, parties can decide that they want it online, they want face-to-face, and on paper. So with COVID, what we have realized that a lot of them still prefer adjudications to be done on paper. So people are not willing to travel. People want to save on time and all of that. And anyway, so they have the right to do that. But if they want face-to-face, by all means, please, they must do that, and they're always welcome. So we've gone back to our old ways, but yes.
Sorry for interrupting you. Is that a specific request that you need to make? Is it standard that it gets done online?
No, it's not standard. What we do when we receive adjudicators, when we receive these adjudication allocation, we'll then write to the parties, we confirm, we acknowledge receipt, we confirm that it has been allocated to me or to Karen or whoever the adjudicator is. Then the parties have the right to a face-to-face or a face-to-face adjudication or an online adjudication, or it can be done on paper. So we found that a lot of them still prefer that it be done on paper, but there are those who want a face-to-face. You know, sometimes we also ask them, can we do this face-to-face? When you look at the complexity of the matter, maybe it would be better if both parties can meet, and yeah, some refuse. So, but yes, definitely, we do face-to-face now and online. Thank you.
Lauren, what are the internal dispute mechanisms? You sort of touched on this in a previous answer. I know through the application form they actually ask you a question: has all internal dispute mechanisms taken or met? How do you determine if this is met?
In most conduct rules or management rules, usually the conduct rules, an internal dispute resolution is made provision for. Even if it is just that you must meet with the trustees first, or if a fine has imposed, meet with the trustees, discuss it. We refer to it as the audi alteram partem, which a principle which means that both parties to a dispute need to be given the opportunity to be heard. And that's what we really want, is that people within the body corporate try to resolve it themselves. So if you are having a dispute with your neighbor, try to meet with that person and discuss it before you come to CSOS. The CSOS must be a last resort. And that's what we we're trying to get to, is to try to resolve it internally. So you must show that you have made a proactive attempt to resolve it with whoever the other party is before you have come to the CSOS. And that's what we're looking for. You must show that. And making that attempt is not just a mere telephone call and saying, I want you to solve this. I don't owe you the money. It's actually sitting down and saying, I want to pay it off. I offer this. Not just saying, I don't owe you the money. I'm not speaking to you. It's not that simple.
Do you usually require proof to be given that this mechanism has been undertaken as well?
Yes, yes. That's why letters of demand for payment are required, and so on, and SMSs, etc. Yes.
Lindiwe, Corin touched a little bit on the 90-day principle and that disputes need to be handled within that time period. CSOS grants you a certain time period to, let's say, for example, an application has been filed, it's been received by CSOS, they've now had a look at it, and it looks to them as if this person may have a case. They provide a person, the other party, the respondent, a certain time period to answer to this. How long is that period that they give a person? And sometimes if a person does not comply within that time period, will the matter just carry on, or is a request sent by CSOS to ask for further response?
Okay. What happens once the application has been received, then it's sent to the respondent. It's called a section 43. A section 43 is sent to the respondent. The respondent is given, it used to be 14 days, but now it's 7 days. The respondent is then given 7 days to reply. Should the respondent fail to reply, or they did not even ask for an extension, it will just be a reminder that you haven't replied, maybe given a day or 2 or 3 days maximum, you haven't replied, your matter will now be referred to adjudication. So before it gets to an adjudicator, it's then sent to the compliance investigators, who then will send you a letter that you've given an opportunity to submit final written submissions, because then the matter you haven't replied to in section 43, we are again giving you an opportunity to reply. If you don't reply, then the matter will then go to the adjudicator directly. So yeah, it used to be 14 days. It's now 7 days.
7 days. Excellent.
Yeah.
So similar to what a default judgment through a court would be, if the person does not reply within that time period, it gets automatically taken through to adjudication. Do the adjudicators hear the matter then just from the one party, or how do they determine that?
Yes, the adjudicator can hear the matter from that. If it's on paper, it will be based on the submissions before you. So you obviously assess the documents. The respondent, upon assessment, you feel that maybe the respondent, maybe the email address was incorrect, or, you then, remember, you're going to confirm anyway. I had a matter where I've written to the parties, the respondent did not reply, but when I requested them if they would be willing to do a face-to-face adjudication, that was the only time that the respondent replied. So based on that reply, it means then I will hear the matter face-to-face. So because the respondent did not reply to that submission does not mean that they cannot appear. But then if it's a written submission, so I'll obviously base it on the papers before me. There is nothing from the respondent for me to consider.
Of course, I've seen, CSOS conciliators and adjudicators send multiple emails to parties. So you really try to contact them.
We really try to contact them.
Some people just don't want to be contacted.
I know, but then we have that obligation because the CSOS adjudicators, we have the investigator powers. So that's section 51. So we try and use that section to get the parties, to get more information from the parties.
Corin, I'm heading your way. We've touched on this a little bit, but I just want sort of an answer to the differences between conciliation versus adjudication. What does the process entail, and what are the main differences?
Conciliation is a process which is a win-win situation, and it really we advocate conciliation. A conciliator is specially trained to encourage parties to meet in the middle and settle. So that is really what it is. It's to encourage parties to sit together and reach a solution. The conciliator doesn't dictate to them, rather encourages parties to come up with a solution between themselves. And as I say, they have to meet in the middle and have a settlement. At the end of the day, they live in the same complex usually, and so the next day they have to drive past each other and hopefully wave to each other and not hate each other. So if that doesn't work, it goes to adjudication. An adjudicator is similar to a judge. They will sit and listen to both sides of the story, and then make a decision purely on the law, on the law, whereas a conciliator will not generally look at the law. They'll look at other issues as well and try to reach a settlement. Obviously, the law is involved. They're not going to make an unlawful decision, but an adjudicator will look at the law, make a decision, and the decision that the adjudicator makes can be enforced in court, as Lindiwe has mentioned. So that is the difference. As I say, conciliation is a first prize, where both parties give and take, and they settle the matter. Whereas adjudication is a win, and it's a win and lose. One party wins, the other party loses. So that's the difference.
So it's like a mediation and court process. Mediation being conciliation and court process being your adjudication process.
Exactly.
Okay. Lindiwe, does CSOS do inspections of the matter when it relates to maintenance on properties?
Currently, we don't have inspectors, but in a few cases, we've requested our compliance investigators to do the investigation. So we are in the process of appointing a panel, meaning a panel of service providers, so who will be able to go and conduct the inspection. I myself, probably my other fellow adjudicators have done that. I have conducted inspections inspection in local. I think it was in Merville or something. Yes, I've conducted some. So yes, we do conduct inspections, but we would like to do more, and would like to use people with specialized skill, to conduct those inspections. The Act allows us to do that. Yes.
I think it's obviously pretty difficult with maintenance claims to sort of see exactly where the problem is. I mean, these things get so complex sometimes that exactly. I think it's a very good thing being able to actually go to the premises. So that's much appreciated. Corinne, you can skip slides for us, please. Okay, my favorite one, collection of levies. Okay, so is it a good idea, Corin, to utilize CSOS for dispute processes, specifically for collection of levies?
It's an excellent idea, and I really would suggest that all schemes use it because it's free, and you will not have to incur any legal costs until such time as you want to enforce or you want to go and do the collection of, so once you have the enforcement and you want to go to the sheriff to attach, that's the first time that you are going to incur any costs, any legal costs, because that's the first time you'll have to go to an attorney. So I would hazard a guess that you're probably going to save in the region of about 15 to 20,000 if you go through that process. Don't wait. You don't want prescription to apply. I know that there is a debate on the legal front as to whether prescription applies or not. We at CSOS are of the considered opinion that prescription does apply to levies. So don't wait for a year down the line to come to CSOS and then collect levies, because it's free. Many people don't get anything for free these days, but come to CSOS. Issue that first notice of dispute. Within 90 days, you're going to have an order, have it made an order of court, and then go from there. Attach the property, attach the movables. It's not going to cost you anything.
Right. Just a little bit of possibly a technical question, but let's say, for example, you've got this 90-day period going. You issued your letter of demand for a specific value, and it's obviously accumulating over that 90-day process. Does that get taken into consideration? Can it be taken into consideration, or are you going to go off what the initial papers said?
No. That's it's a massive advantage compared to a summons, because you're going to get your order that's completely up to date on the amount that's up to date as at the date of the issuing of the order, which, unlike a summons, you've got to go on the date of the issuing of the letter of demand. So, for example, I know that myself and Lindiwe, we go with the amount is at the date of the issuing of the order, and that's how it should be.
No, that's a massive plus from any collection perspective, being able to actually include those new values, because as everybody knows, court process can take incredibly long, and you're issuing a summons for a specific value. That value is just going to increase over that period, so that you can actually make an order based on the new value rather than the letter of demand value is fantastic. It just makes so much sense. Right.
Absolutely.
Lindiwe, possibly something that fits into the previous question, but what would your suggestion be for schemes struggling with collection of levies? Obviously, switching off electricity is a great idea. Stopping access is a fantastic idea. I'm joking now, okay. But what would your suggestion be for collection of levies?
It sounds great, but it's a no-no. You can't switch off electricity. You can't even limit the usage. You can't deny access. You can't do all of those things. The best way is to bring the matters to CSOS as soon as possible. You don't want to wait until someone owes 400,000 and then we still apply prescription, until we're told otherwise. CSOS's stance is that prescription is applicable in these matters, as Karen has already mentioned. What is important? Lodge the dispute. It does not cost anything. It does not cost anything. The process is even quicker. We've reduced compared to the court process. Seriously, 90 days. It's really not much, especially area levy matters is even quicker than 90 days. So it would be better bring these applications early. So it helps the scheme as well, because if people are not paying, and you can't even switch off electricity without a court order. So it's for the best interest of the scheme. Managing agents, please bring these matters as soon as you possibly can. I know we have received a lot of matters from Trafalgar, so please keep doing that. Please bring the matters early. That helps, saves the scheme and the owners. Yeah.
Lindiwe, then possibly just a second question for you, and then I'm going to keep the last one for Karen. What's the best process to follow up on CSOS disputes? Should you contact the conciliator, the adjudicator during the process? What's the best way to follow up?
Okay, for all regions, we do have a complaints, meaning a complaints email. But the best way is to, if you received an email from Lindiwe, follow up with Lindiwe. You know, if it's with the conciliator, you know who the conciliator is, follow up with, you escalate once you realize that the conciliator or the adjudicator is not doing anything about my matter, is then that you can escalate to that complaints email address. So for GP, there's a GP complaints email address, KZN, same thing. And the Western Cape, they also have a designated email address for complaints. So
Follow
that's
up
how you
and then follow that process. That makes complete sense. Yeah.
Yes.
And everybody I've been in contact with CSOS, I mean, it's same day answers that you get through. So yeah, it works. Then final question for you, recurring disputes. We have this a lot, that matters are continuously brought up and taken through to CSOS regarding the same matter or very similar matters. How best to deal with that as the respondent? What would be your tips for that?
So I'm going to assume that you're speaking about the same person bringing continuous applications. Okay. There is I'm not quite sure which subsection of Section 39 it is, but there's one that speaks of nuisance. There's two, one of nuisance and one of noise nuisance. And you know, I'm just trying to think of what the term is. People bring applications to court against people, a vexatious litigant. So this is a similar thing that you can, again, you've got to get your evidence together. And if people do that, I have certainly granted applications to declare somebody a nuisance. And that can be done. You can declare somebody a nuisance and get an order compelling them to cease and desist from being a nuisance, causing a nuisance to the trustees, for example, and you know, having an impact on the continued peaceful administration and management of that scheme, for example. So, you know, sometimes you have to be creative in the way that you do it, but it must fall within Section 39, and you have to be creative in the way that you set it out. But as long as you have the evidence, you've built up the evidence, that's what you have to do.
Okay, and that would constitute, I mean, it's very difficult to say, but when we're talking multiple year, it's not just to do with the applications itself, but it's also to do with the behavior, the attitude of the party within the scheme.
If you have somebody that persistently sends emails to the trustees 5 times a day or 10 times a day, and the trustees have difficulty managing and administering that scheme, and so does the managing agent, then I would say that you certainly have sufficient evidence to bring that matter to the CSOS. Otherwise, you're going to have to go to court, and there is court precedent, particularly on this matter. But bring it to CSOS. It's going to be for nothing.
Excellent. Thank you very much, ladies. Thank you, Corin. Thank you, Lindiwe. Andrew, I'm certain there are other questions that have come through from the chat.
Yeah, good. Thanks, Peter. I'll pose one. Karine might have picked up some others. We did skip your question on precedents. So, Lindiwe, you know, precedents, I think, are available. I know Paddocks has published a collection of precedents. They must be on the CSOS website as well. Would you advise trustees to refer to those with their efforts to resolve disputes internally? Or how else should they be applied to try and streamline the whole dispute process?
Okay. Yes, the adjudication orders are actually, we have a responsibility to make sure that we publicize those on the website, right? I would encourage parties to use those precedents. And the fact that it was granted in one case and rejected in another does not mean that there's a contradiction. Parties must make sure that when they use the precedent that they find on the website, it is exactly as their case, because each case is treated on its own merits. So, but it is a very good start. You know, those who use our precedents actually also assist us as adjudicators, because when we go through the case now, we know what to analyze, we know what to look for. So if you've used that precedent and then another adjudicator is able to understand what the issues are, as Karen has said, there are instances where you find that people are just vexatious. They just bringing applications unnecessarily. So you'll see that when you go through those precedents, you'll see that, but cases like these are dismissed. Why do I even have to go through the same process? In most cases, you go through maybe 5-10 cases, all of those have been dismissed. It gives you an idea as an applicant. Do you still want to proceed? You know, so they do help. They do help because in almost all of them, they have case law. You can go and refer to that case law. So when you do bring that application, it's well thought through and it's well presented.
Right.
It assists you as the applicant as well.
Yeah. And I think a managing agent can play a role there because, you know, we can navigate those precedent libraries. We've got access to some of them already, and we can provide those more quickly to trustees or owners if they ask for them. So think about that as well. Corinne, if I come to you now, I would have thought that some of these disputes, you know, go back to rules, conduct rules, which are not clear, which are not modernized, which do not regulate difficulties on the scheme. Is that an observation that could come up at the adjudication, perhaps in the adjudication order, and a recommendation for trustees to take that on board as a signal to modernize their rules and then enforce it more clearly going forward?
Andrew, without a doubt, you've hit the nail on the head. Many schemes haven't modernized their rules. I mean, they're still looking at rules from prior to 1986 or just after 1986, and it would be an excellent idea to do that. You know, especially with regard to pets that are not comfort pets, but that assist the owners. I saw a matter today where an owner had a dog that was truly an assistance pet, and that has now become quite common. And trustees are not just permitted to say across the board, well, sorry, that's not allowed. And the constitutional impact of things has changed, and the trustees must move with the times. So yes, absolutely. And I know that Trafalgar publishes many articles on their website that you have written, and I think that if your schemes would take note of those things and bring it up to date, that would be of great help to them.
I mean, just for commenting on that, there are specialist attorneys, I won't mention names, but they offer a service to help with modernizing the rules. The cost estimate is $5,500 to $8,500, but it does go a very long way in streamlining the administration, the conduct, and the way disputes are handled, because it's much clearer and better targeted at difficulties at a particular scheme. So definitely something to take away. Yeah. Lindiwe, just in terms of that enforcement of arrear levies through CSOS, I'm under the impression there's certain exclusions in terms of the CSOS rulings, interest, legal fees, debt collection fees, etc., which are a limitation in terms of the CSOS process and the CSOS ruling. Can you just comment on that, please?
Okay, with the arrear levies,
yes,
it's the exclusions. It's, you know, it's clearly set out in the STSMA, you know, Section Title Schemes Management Act sets out that, and the prescribed management rules, that for you to add these costs, right, there must be a resolution. So if you are going to add these costs, the legal costs, for instance, those costs must be taxed, right? So if the costs are taxed, and if there is a resolution for the interest that has been charged, there is no problem. The times where these matters these costs are excluded is where there is no resolution and the legal costs, legal fees are not taxed. So it goes against what the prescribed management rules are saying. So in those instances, then these costs will be excluded.
Okay, and debt
So
collection fees,
when you bring the application, the debt collection, you must submit that certificate that yes, you are a debt collector. So if you have the certificate, all those costs will be included because you've complied with everything. So the ones that are excluded are the ones which do not form part of which you did not submit the required resolution. So in those cases, and what we try and do, we apply that section 51, we'll inform you, request it, that please submit proof, please give us the debt collector's certificate, give us a resolution that authorized that interest, and that interest, interest is limited to 2% per month. So you come and charge an interest of 12%, that will definitely be excluded. So those are the limitations.
Okay, no, thank you. Corinne, just a quick, yes.
May
Please.
I add something to what Lindiwe was saying? We have many instances, as I'm sure you're aware, where there are charges because management rules 25.4 and 25.5 say that you can't charge something unless the owner has agreed to it, etc. And then you have trustees trying to pass resolutions in terms of which legal fees may be charged on an attorney and client scale, or you can charge them without having them taxed, or etc. etc. So things can be charged. So the trustees pass resolutions that are contrary to the management rules. Now, and then they submit it to CSOS and say, well, we can because we've passed a trustees resolution. Just remember, the trustees out there, that in order to change a management rule, you need to pass a unanimous resolution. So trustees' resolution to charge those amounts on the levy account is not sufficient. You need to pass a unanimous resolution to change the management rule. So if you submit a resolution by the trustees to charge certain amounts to the levy account, such as administration fees, doesn't cut it. You need to change the management rules. That's just the one thing that I want to mention. Sorry, Andrew.
No, thank you, Corinne. We're nearing the end of our time, but maybe one or two last questions. Corinne, a few questions have come up about overcrowding and about illegal building sort of constructed, on common property or within sections. Now, would those automatically be council building inspector related out of the jurisdiction on CSOS? Or would you play a role in terms of adjudicating disputes of that nature?
Yes, we can play a role because you can fit it into section 39. But I can't say offhand, but I know that we have. But just remember that they do fall within the Sectional Title Schemes Management Act, as you know, but whatever has to be brought to CSOS has to fit into Section 39. We cannot order, for example, that something has to be demolished because that doesn't fall within our jurisdiction, so that would have to be brought to court. But if it fits into Section 39, then we can adjudicate it.
Great. All right, so we're going to come to a final comment from each of you, if we may. But, just my closing thought for today is that, I see so much circular debate and circular emails in the case of disputes, lots of backwards and forwards, between trustees and owners, between owners and owners, etc., surrounding differences in agreement. And it consumes a huge amount of time and energy for the people concerned, the trustees, the managing agents, etc. So I've tried to sort of guide our portfolio managers to be much more decisive about determining when is a dispute, and normally it's very late. It can be determined a dispute much earlier in the process, determining that the internal remedies have been exhausted and then quickly escalating to CSOS, because it's very helpful to have an objective, independent, authorized third party examine the facts, interview the parties, and then come up with a binding external ruling. And it makes a decision, it moves the process forward, it short circuits this whole, circular, endless correspondence, which takes so much time. And, I think it's just a takeaway to be decisive, to be more time efficient, and to realize that a third-party adjudication can be very helpful in moving things forward and reaching closure. So, Lindiwe, just closing comments from you from today, but, many thanks indeed for your contribution.
Okay. Thank you for inviting us. My closing comment. Parties have the power, if they can just try and resolve matters amicably among themselves. We find that a lot of matters are referred to adjudication unnecessarily. It gives us so much power that we actually don't have. Parties must try and resolve the matters amongst themselves. Use conciliation. Use conciliation. In conciliation, the conciliation process, give and take, be willing to let go of something. At least it gives the parties the power to decide their fate, as opposed, because these are neighbors. So we encourage parties to try and solve, be neighborly, just be neighbors and try and make this work for everybody. But thanks. That is my parting.
Thank you. And Corinne, from you?
My parting shot is use the CSOS. Use it. As an attorney or as a previous practicing attorney, I know how expensive legal fees are. So as I've said multiple times today, the CSOS is free. How often do you find that? Use us. Thank you very much, Andrew.
Thank you. So we've come to the end of our time. So we've got contact details on screen. You're more than welcome to contact any of us. We do try and reply to questions promptly and give feedback, or we will refer it for better feedback. So that's welcome to you. So I'd like to really thank our special guests from CSOS. Thank you so much for your time. Your contributions were highly practical, relevant, and useful. So we appreciate that very much. We will respond to those that have asked for the recordings, for the Q&A record, and for the slides that we will send out in the next day or two. And we will hopefully see you again at our next webinar on the 26th of October. All right, good night, everybody. Thank you, and very much enjoyed the discussion tonight. Good night.